Everyone. Today I am going to discuss with the topic arrest procedure. Indian Constitution. Indian Constitution under Article 22 explain about protection against arrest and detention. Protection against arrest and detention. Okay. Here the protection against arrest detention in certain cases, it provides certain safeguards if the personal liberty is curtailed by arbitrary arrest and detention. Okay, this is the main important things. While the police officer or investigation team arrested any one of the innocent person or accused person or offender, whoever it may be, they should follow rules and regulations as per the Indian Constitution and also direction given by the Supreme Court, guidelines given. Okay, that guidelines also should be followed by the police officers. The constitutions explain about 22 subclause 1. It's clearly indicated no person who is arrested shall be detained in custody without being informed. This main category, without being informed, as soon as may be, as soon as may be, of the grounds for such arrests. What kind of arrest and what is the reason the police officer arrested to the particular offender? They should intimate to the offender relatives, advocates, and also such arrest nor shall be denied the right to consult the legal officer or advocates and to be defended by any legal practitioner of his choice. The arrested persons having rights to choose legal officer, legal practitioner, or any advocates. So the police officer not denying these rights to the accused by arrested person. Okay. The point number 2, every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey. Excluding, not including. Okay. For example, if any one of the arrested police stations, okay, police officer, from the police station to magistrate, the distance will not calculated. Okay. Because the traveling, once they started from the police station, okay, that's all. Up to arrested time and up to detained time only calculated by the police officer as per the Indian constitutions. Okay. The journey from the place of arrest to the court, the magistrate, and no such a person shall be detained in custody beyond the 24 hours. Okay. Authority of the magistrate. And also, Article 22 subclause 3 explain about saying that point number, there's this point. Okay. The third point is nothing in class Article 22 subclause 1 subclause 2 what we discussed just now shall apply to any person who for the time being is an enemy alien or to any person who is arrested or detained under any law providing for preventive detention. For example, preventive detention is available. Okay. Prevention of crime. Okay, if any habitual offender or any one of the person planning to do the things wrongful to the society. So what happened is the safeguardly the investigation people or police officer, what happened, they rush to arrest the particular persons. The point number 4, 22 subclass 4 explain about no law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months. For example, if any one of the accused person arrested inside of the prison, okay, they sent to the jail, not a local police station jail. Once they are surrendered or brought before the magistrate, what happened? Extend the uh, judicial custody to the minimum 3 months without giving any bail. That is preventive detention, because one person or any one of the accused as a habitual offender or is in two or three four little bit crimes, or threatening to the people, threatening to the shop, or getting money due to threatening to the any shop owners, or pickpocket peoples. So the within a year, that particular robberies or particular offender did the wrong continuously, and also that particular people wants to contest the band against the government or society, and also the accused person wants to create problem in future. They are planning that, so automatically the police officer having rights to arrest immediately, not doing the that kind of arrest. So the Constitution, Article 22, sub clause 4 and 5 is clearly explained about not to do the this kind of error things in society, and to avoid the crime in future. So prevent the crime, okay, prevention of crime, so that they will book the case and detain into the custody and verified he did wrong, he will do something, three or four case he did in petty cases, and also he or she will threatening to the society regularly and habitual offender. In future, he or she should be do the wrong things for affecting the public peace in future. So this is precautionary steps will do the police officer having rights as per the Indian Constitution according to Article 22 subclass 4 and 5. So what happened? The 22 subclass 4 clearly explain about the detained person sent to the prison after inquiry from the magistrate. Okay, what happened? The magistrate directed to the offender to judicial custody. In this situation, what we discussed 22 subclause 1 and 2, intimation to the people, and 24 hours, and the legal officer, this kind of, no, not necessary, this kind of peoples, okay. And also this no law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months, unless an advisory board consisting of persons who are or have been or qualified to be appointed as judges of High Court as reported before the expiration of the set period of 3 months, that there is, in its opinion, sufficient cause for such detention. And also, provided that nothing in this subclass all authorize the detention of any person beyond the maximum period prescribed by law or any law made by Parliament under subclause 7 subclause B of Indian constitutions. So Article 22 subclass 4 subclause B explain about this kind of such a person is detained in accordance with the provision of any law made by Parliament under subclause 7 subclause A and B. Okay, we'll go to the Article 22 subclause 5. When any person is detained in pursuance of an order made under any law providing for preventive detentions authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made, and shall afford him the earliest opportunity of making a representation against the order. In this section, in this article 22 subclass 5 explain about those who are detained person inside of the prison. The advocate will not representing, okay, the individual person having representations, he only claim. The legal officer don't have rights to act behalf of inside of the prison. The legal officer assisting to the people. So this accused person personal representation needed. So based on this personal representation, he or she will prepare the document and submit to the petition to the jail superintendent. This jail superintendent forward to the particular complaint to the advisory committee. So advisory committee will monitor and scrutinize within 3 months and pass the order. Okay, if the order is passed in favor of prisoner, detained person, preventive detention act person, based on this order, after that only the lawyer, behalf of accused, the lawyer will contest the case and he can claim the bail petition along with this order copy received from the advisory board. Then court will satisfy. After that, inquiry bit from the public prosecutor from the court. Once satisfied, bail order will be passed by the court. Then he will be released by the bail. That is another practical position. According to Article 22 subclass 6, clear about nothing in class 5 shall require the authority making any such order as is referred to in that class to disclose facts which such authority considers to be against the public interest to disclose. Articles in point number 7, Parliament may be law prescribed. The three provision is available. One is the circumstances under which, under the class or classes of cases in which a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board in accordance with the provision of subclass A, that meaning is subclass 4 subclass A. So Article 22 subclass 7 of Indian Constitution explained that this Parliament Parliament provisions. And according to same Article 22 subclass 7 subclass B explain about the maximum period for which any person may in any class or classes of cases be detained under any law providing for preventive detention. And Article 22 subclass 7 subclass C, the procedure to be followed by an advisory board in an inquiry under subclass 4 subclass A. And also I just wanted to explain about the rights under Article 22 are available to both citizen of India and a non-citizen of India under the two categories. The point number 1, whether the arrest or detention is made under ordinary law for commission of crimes, ordinary law. Okay. The point number 2, whether the detention is made under the law of preventive detention. Okay, these are all arrest procedure. Okay, Article 22 subclass 1 to subclass 7 explain about arrest procedure. We'll discuss on next YouTube classes or video what are the provision available to the arrested person under ordinary law. We already discussed 20 subclass 1 subclass 2. 20 subclass 1 is ex post facto law. 20 subclass 2 is double jeopardy. Okay, we'll discuss on later one by one. Okay, thank you, bye, take care.